We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on panel for the 5 cases we have on the list for hearing this morning are Justice Amy Lynn Blake and Justice James Lemire. They will be with me as the panel for all 5 cases. The first 3 cases are criminal matters. We will take a brief recess after the conclusion of the third of those cases and then resume with the remainder of our list consisting of 2 civil cases. The first case on our list for hearing is case number 2019 P1786, the Commonwealth versus Shane E. Harding. Mr. Driscoll.
Thank you, Chief Justice, and may it please the court. My name is William Driscoll, and I represent Shane Harding. This court should decide this case based on Peno and Creighton, as the admitted prior and subsequent bad act evidence caused 4 irreversible mistakes. First, it required the defendant to defend against uncharged crimes. It confused the theory of defense. It diverted the jury's attention from the 2 charges. And finally, it prejudiced the verdicts because this court cannot say that the propensity evidence was not relied on by the jury to find beyond a reasonable doubt standard. Now, Peno identifies 4 key criteria for deciding whether there was error in a bad acts case. First, the court did not properly consider the probative value versus the prejudicial effect of the bad acts evidence in this case. The judge allowed all evidence in because, as he said, the motion to suppress the police statement was denied. Therefore, it's coming in anyway. What the judge failed to do is to take a look at the prejudice for each piece of bad act evidence, prior and several subsequent bad acts, but he failed to do that. Had he done that, he would have found that the prior bad act was his motivation of the day that the jury needed to hear. The victim knew what the prior reason for being on his run from the authorities. It was a failed drug deal. That's what she knew, and that's what the jury should have heard. They should not have been confused by Mr. Harding's abduction and attempt to steal money from a woman in a parking lot just within a half an hour earlier, before he arrived at the apartment.
Mr. Driscoll, this is not pure prior bad acts evidence in the sense that we often see it. This was all part of a continuing string of events that began with the failed drug deal, but then encompassed a variety of different responses by the defendant as he became increasingly desperate to flee the country. Isn't that a fair characterization of what took place here?
Well, the difference here is the bad acts that were allowed into evidence really had nothing to do with the victim. No,
but they had a lot to do with the defendant and his motivation, his state of mind, his the context in which all of these activities occurred. Now, the fact that several of them were uncharged is at least in part due to the fact that they occurred in another state.
Yes, and some of those were charged and some were not charged in the other state.
I understand that, but if they had all occurred in Massachusetts, there would have been very little contention, it seems to me, little basis to contend that they could not have been joined for trial together.
That is true. However,
okay. So the analysis on joinder would take into account many of the same concerns about potential prejudice or confusion that you're invoking now to suggest that they ought not to have been.
It's the existence of whether or not charges he stood trial for charges. Now, if they could have been charged in Massachusetts, but were not brought, then why should he defend against those in his trial?
He wasn't defending against those charges. They were not placed before the jury. That was simply contextual evidence given to the jury for an understanding of how this string of events unfolded that led to the rape of which he was convicted.
But it was highly prejudicial because it was totally unnecessary. The victim knew he was on the run. She knew he was a felon. He was on parole and thought that he had knocked over a store, as she put it. However, she learned from him that, well, the reason why I'm doing all this is because I had a failed drug deal. That's why I'm on the run.
But why is the victim's state of mind of significance here? It's really the defendant's state of mind, and also not what the victim knew, but what's important is what the jury knows and understands.
Right, and what the jury learned was just prior to this, Mr. Harding had abducted a woman, totally separate, had nothing to do with. He abducted her to rob her. It had nothing to do with being on the run. He was on the run with the victim, and the victim knew why. So it goes beyond her state of mind. It goes to his state of mind. He was on the run because he had committed a crime.
But wasn't his robbery of the other woman related to his efforts to evade, to escape the country?
He had several reasons for wanting to escape. He felt his life was pretty much over, being on parole.
No, but I'm talking about the robbery. I'm talking about the robbery. The robbery was intertwined with and in furtherance of his effort to leave the country, right?
Yes, all of his actions from when he woke up that day and even before that, they were working on his resume because he was having difficulty finding any employment. He was on parole. His life was going south.
Yeah, but his desire to leave the country wasn't had very little to do with his resume.
It had to do with the fact that he had no life. He was a level 3 sex offender, and
he feared retaliation from the drug dealers. What is why he was looking to leave the country, right?
Right. He was looking to leave the country because he had committed a serious crime. He knew he was going back to prison, and the serious crime was the drug dealer.
Well, I think he also was worried about extrajudicial retaliation as well. So both were motivating factors, and he, in response, made a series of what we might describe as ill-advised choices that culminated with, at least for our purposes, with the rape of this victim. But all of that was part and parcel of an overall string of desperate activity that bears on his state of mind and the jury's understanding of it.
But there was absolutely no reason to bring all the subsequent bad acts. They had nothing to do with why he may or may not have raped the woman. The woman voluntarily drove him away to evade authorities because she knew he was on parole. She knew he had a gun. She volunteered to do this. She did not volunteer to be kidnapped or, as she says, raped. But the subsequent bad acts only gave more propensity evidence that he had a tendency to kidnap women. It made absolutely no difference what happened afterwards, all the way up through his arrest. His arrest, there was no question or no need for the Commonwealth to explain the circumstances of his arrest. The fact that they had caught him is all they need to know. He had made a statement. In that statement, the real pertinent piece of information is the fact that he says, well, you know, she is we do have a relationship. So she may not have wanted to have sex with me, but the issue was consent. So was it rape or was it consensual sex? That was the key issue. It had nothing to do with all the other propensity evidence that, as the Commonwealth pointed out strongly in their closing argument, and we're not saying the closing argument was improper because it was based on the evidence, but the evidence should not have come in. The Commonwealth emphasized that this is a really bad guy that was basically out to cause destruction, that he was looking to prey upon other women. That's a quote. And a desperate man already on parole with nothing to lose, which made him a very dangerous man. Now, his propensity brought into this made him automatically guilty of kidnapping. And hey, if he can kidnap a woman in the morning, kidnap a woman he must have raped. And the Commonwealth stated this was their theory of the case while at the motion in limine hearing.
You keep describing this as propensity evidence, but I find it, what you're talking about is a series of events, all part of a single stream that illustrate his state of mind and motivation at that time. The fact that that is the Commonwealth's theory of the case doesn't make it improper propensity. It just illustrates that what his motivation was as he was going. Nothing to lose is certainly permissible as a motivating factor, isn't it?
It is if it's not extremely prejudicial, which it is in this case. The 4-point test in Pena shows that.
Well, I mean, the most important evidence is usually extremely prejudicial. That doesn't make it inadmissible. It's only a question if it's improper, and if it bears significantly on his state of mind and his motivation, that's not improper.
No, but Creighton tells us that bad act evidence is unlike any other evidence. It is so extremely prejudicial that it's not a situation where one looks at the probative value versus the prejudicial effect in general. If the probative value is no greater at all than the prejudicial effect, which is more important when it comes to bad act evidence, it should be excluded. And the Commonwealth made it clear in their motion in limine hearing when all of this was brought up. That's why it was all preserved. They made clear that they plan to prove what happened in the middle to the victim by proving the prior bad act and the subsequent bad acts. So because those happened, the jury were to believe that the crimes he stood trial for were proven beyond a reason. They stated that in their argument to the judge in the motion in limine hearing. So the 4 points under the Pena test, the judge did not look at the prejudicial effect, did not properly look because it was coming in anyway, the judge said, which is untrue. The mitigating instruction was not strong enough, just like in Creighton. This is a case where there was an overwhelming probability that the jury would be unable to follow the court's instruction. It is a rare occasion, but this is the case, just like Creighton, where the jury could not follow an instruction. I'm not saying that the instruction was wrong. I'm saying that the jury could not follow it. There was cumulative evidence brought in. It didn't matter what he did before because the victim had already been told. The jury learned exactly what his motive would have been. He had committed a heinous crime. He's on the run. And the bad acts evidence were all so similar to the charged offense that as the Commonwealth stated, they wanted to prove what happened before plus what happened afterwards proves their case beyond a reasonable doubt. But that places the defendant on trial for uncharged crimes. And the Commonwealth cites 5 cases that don't apply. In Bonds, that had nothing to do with a character. That had to do with a medical condition, the woman's mental state, her mental health. Cites Drew, Bradshaw, Hoffer, and Shalfo. In all of those cases, it mattered the prior events pertain to the victim. What happened? What was the interaction between the victim? Why did the defendant kill the victim? In this case, what happened to the woman in this case really had nothing to do with the preliminary bad acts. They were not motive evidence. The motive he was on the run was the heinous crime, which came out through the victim's testimony. So there was absolutely no reason to continue to prove his guilt by bad acts.
How does his interest in fleeing provide motive to rape?
He's saying that he although he may have kidnapped her, he did not rape her. It was consensual sex.
I understand, but it seems to me that it's not just his interest in fleeing the jurisdiction, but also his increasingly desperate state that bears on his decision to commit the rape, at least for the Commonwealth's theory.
Which would go to the kidnapping charge, but not to the issue of consent. I see that I'm out of time, Your Honor.
Thank you. For the Commonwealth?
Good morning, Your Honor. Stephen Greenbaum for the Commonwealth. I would rest on the arguments set out in my brief and attempt to answer any questions if there are any.
I have no question.
Seeing none, thank you for a concise presentation.
You're welcome.
The case is submitted. We will move to the second case on our list.
Thank you, Chief Justice and the court.
Thank you.
Thank you.
We are live and on the record.
We continue our list of hearings with our next case, case number 2020 P645. This is the Commonwealth's appeal. It is the Commonwealth versus a juvenile. Attorney Jansen, you may begin.
Thank you, Your Honor. May it please the court, Catherine Jansen for the Commonwealth. The Commonwealth respectfully requests that the court reverse the allowance of the motion to dismiss. I think it's important to note at the outset, sometimes I think it gets lost, that this is a considerably less exacting standard of probable cause, that any and all inferences should be looked in the light most favorable to the Commonwealth. And so long as each element of, in this case, threatening to commit a crime is met, then there's sufficient probable cause at this point. And I think I would first just address the First Amendment issue, which was raised by my sister on appeal. And I would say that this is not protected speech. This would come under the guise of a true threat. A true threat is something that doesn't have an expressive purpose, such as political or artistic. It was not mere hyperbole. It's intended to put the target in fear. And I think here, saying in the context of this case, where the teacher had basically this meeting had been called because the teacher had sent an email to the vice principal saying, I'm having behavioral issues with this juvenile, and I think he truly hates me and that he wants to kill me. And that was the start of this meeting. And then as the meeting's going on, the juvenile gets more and more agitated, and then eventually angrily says, I'm so angry, I want to kill that bitch. I think that rises to the level of a true threat. There's no other purpose to that. Any question about, just like, do you have a question?
Attorney Jensen, I guess, do we have any cases where the fact pattern is like this one, which is where the target of the threat had apprehension before the threat was actually made? I couldn't find any. I'm wondering if you've seen anything even remotely akin to a situation where the victim had expressed prior apprehension. And I ask that because your sister makes the argument that for the test should be a subjective one. I know you say under Maiden it should be objective, but that his age should also factor into what his intent was. And to the extent that there's things that happen before this threat, what weight do we give that, or how do we consider that in the calculus of the probable cause determination?
Sure, Your Honor. I would, to answer your question, your initial question of did I see a case where there was an apprehension before? I did do a pretty extensive review of the case law, I hope, and I did not see that before. However, I do think there's case law that says that threats are all contextual. I think that this is part of the context of the threat. I think it goes to, if we just view it as an objective standard of reasonable, it would be reasonable to have an apprehension of the intent and ability to actually follow through with this threat. And I think that is one part of the full probable cause analysis as to that Fourth Amendment. As far as excuse me, not Fourth Amendment, Fourth Amendment. So, and as far as the subjective, whether or not there should be a subjective test, I understand that was taken, and what my opinion is from dicta from Shali. To me, it doesn't seem as if a subjective fear is necessary. It not only because so long as the speaker intends to communicate the threat, that's sufficient. The case law is clear that the target need not actually learn of the threat. So if the target need not have learned of the threat, then how could you have subjective fear as an element and requirement? I think the true threats test, which was discussed in Shu, when we talk about is there an expressive purpose or not, or some other reason besides just intending to put somebody in fear. And I think Shali, it basically says we look at the elements to see if the elements are met, that's going to protect against a First Amendment violation. And I think here at the probable cause analysis and stage, I mean, we're not going to put, the Commonwealth's not going to put their entire case in a police report. I think quite frankly, a lot of times it's bare bones. And some of the cases are hard because they come after there's been a trial. So there has been evidence and testimony that the teacher might very well say, I was afraid. And, a characterization from a third party, I believe it was the resource officer or the police officer who wrote the report about how the teacher was feeling. I do think that probably would rise to the level of subjective fear, especially within the context of her prior email, which started this whole thing, but I don't think it's required.
With respect to his argument that his age should be a consideration in terms of what he said and trying to cast it as hyperbole, are you familiar with the case of Valentin v. out of our court?
I am. I just saw that yesterday, Your Honor.
Okay. So there we basically said that things like age are a proper consideration for the fact finder, not for the probable cause determination. I'm assuming that you agree with that.
I do, Your Honor.
Okay. So what do we make of the fact that the people at the school didn't report this for 4 days, if it was that concerning?
So I think that's but one factor about reasonable, whether or not it could have been before the elements met. But I also think it appears to me, if I'm correct looking at the dates, that this occurred on a Friday, I believe, and that this, they started investigating it on a Monday. And this is a juvenile. So I think the fact that they were doing talking to the vice principal, talking to the principal, talking to the teacher, looking about his prior history, whether or not, there is reference in the record in the police report that there had been another at least case taken out, but also about his prior history. So I think, it's in the context of this is a school, this is a juvenile, the fact that, probably just that way they could do their investigation. I think that doesn't undermine the fact about the fourth element and the reasonableness of apprehension of intent and ability and this, how seriously they took this.
Well, I would suggest we could also consider her apprehension prior to the threat as part of her apprehension.
Absolutely.
There was already evidence of it. All right.
Absolutely. And I think that just, it's a factor that goes into it all. I don't think subjective apprehension is required. It's just whether it would be reasonable. And here it would be reasonable. There's a pattern of conduct. There has been evidence on the record that de-escalation tactics have not worked with the juvenile by talking with statements from 3 people familiar with the juvenile. And the SJC has taken judicial notice of the fact of violence in schools and that this is a possibility and that this does, quite frankly, it's part of the context of this case that justifies some reasonable apprehension. And speaking of judicial notice, unfortunately, we are all aware that juveniles have killed their teachers. So
yes, but is there any indication in this case that that this juvenile had the means to do so?
Well, I would first say under this, I'm not going to pronounce this case right. The actual physical intent and ability to do it in that moment is not necessary. The fact that he could carry out in the future is enough, and I think we meet that here at a probable cause standard. Based on the record in the 4 corners of the police report, which this court is constrained to reviewing, I think beyond the fact that he whether or not he had a weapon or not, that's not part of the record. Or if he had in the past, that's not part of the record. However, what is part of the record is that he has, in a variety of scenarios, whether it was a basketball game, really getting upset and clenching his fist, or the context of a classroom, banging his fist and kind of just not being able to have anger management.
I have some other questions for you on anger management as it relates to his intent that the threat be communicated to the teacher, but I'll get to those a little later on. You have confirmed my understanding that there was no indication in the record or any evidence that he had or had access to a weapon.
That's correct in the record, but I don't think that's required. I mean, I would point to, I believe it's just where the defendant in that case was writing a letter to somebody, and I believe it maybe was a threat to kill, and he didn't have the ability to do that. But there was, when he got out of jail, or he could have somebody from jail kill her. I mean, I don't see how it's different from this, because he didn't have a weapon there, or there was no written out plan there. And again, this is the probable cause standard. A lot of these cases that have addressed this deal after trial, where the evidence has been flushed out.
Let me turn to the other question I foreshadowed a moment ago. The description in the police report was that he became increasingly agitated in the meeting with the vice principal, culminating in his utterance of the statement that's at the heart of this case. As I understand the Commonwealth's theory, in the circumstances, the juvenile is presumed to have been aware that his threat would be communicated by the vice principal to the teacher, and that he intended that it would be so. And I guess I'm having a little difficulty if we take into context, he's worked up to a lather, and he makes what is clearly an ill-advised statement to the vice principal. But what's your strongest theory? What's your strongest basis for suggesting that he intended for that to be in fact communicated to the teacher?
I think the strongest theory is that he knows that he's being brought in based on communication from the teacher, based on past behavior in that classroom where he's exhibited that, quite frankly, anger towards the teacher. And then he knows this vice principal is going to tell this teacher. I would also point to the fact that blowing off steam, to the extent that this is blowing off steam and he's aggravated, I quite frankly think that's a jury question, as discussed in Valentine, and also whether or not he intended. I think at the bare bones of probable cause, the less exacting standard, this was sufficient to show that he intended to communicate, especially in the context of the relationship with the teacher. And I think we have to look at it in light most favorable to the Commonwealth. Yeah, he could have been blowing off steam, but he also could have just been like, you know what, I'm mad, you tell her this. So, and I think you have to look at it in the light most favorable to the Commonwealth. I know, and this is, as far as charging decisions, the Commonwealth taking this, there's clearly a basis in the record that there's a pattern of conduct and background here. So this is not, quite frankly, I know it's addressed in my sister's brief, that questioning why we would take this out and with the whole juvenile justice reform. But I think at the bare minimum, this is sufficient, and it's not an overreach of prosecutorial discretion either. I'm happy to entertain any other questions the court has any. Otherwise, I'm also happy to rest on my brief.
Seeing none, thank you.
Thank you.
From the defendant.
Thank you, Chief Justice. May it please the court, Lauren Russell for the juvenile appellee. We're asking the court to affirm the dismissal of the complaint. Under the circumstances, the alleged statement could only be reasonably interpreted as inarticulate venting by a 13-year-old boy who was blowing off steam, uttering hyperbole, blurted something out in the heat of the moment. It wasn't.
Where would it cross the line then, in your view, into criminal? I appreciate your argument, the context in which it was made, his age and all of that. But, people say, somebody cuts me off and I beat my horn and say I could kill them, right? That's what you're basically saying this is. But here, what strikes me as different is we have the interaction between this teacher and this student that was not a good interaction, that actually led to the email that created the meeting where he made the threat. And so I see those facts as different than me being upset that somebody cut me off on the road. And I appreciate the hyperbole argument. I'm trying to figure out where that line is.
Sure. Well, Your Honor had asked the question before of the Commonwealth about the email before and what weight to be given, context that had happened in the past. And I would point the court to Walters and Troy T, where there was really quite a lot of hostility between the parties. They're prompting people to get 209A orders for years, really violent and assaultive conduct in the case of Walters. And even then, when the defendant in Walters posted a picture of himself holding a gun and indicating his will to bring to justice the alleged victim and her partner, that was not sufficient for a true threat. Now, it wasn't a criminal threat, but I think criminal threats are interpreted in a way to avoid constitutional problems. I don't think it's dicta when Shawley says that the free speech issues in the crime are resolved by making certain requirements. And I guess that would be another aspect of my answer to your question, Your Honor, which is that the line is all of these things. There are 5 specific elements. There's the expression of intent to inflict a crime, the ability to do so in circumstances that would justify apprehension, the subjective intent to instill fear, the subjective intent to reach a third party if it's not made directly, and the actual fear that results in an alleged victim. I think all of those being borne out by probable cause at this stage would separate the kind of hyperbole in this case and in the traffic incident case that you pointed to from a true threat.
So how do you compare or contrast these facts with Milo M?
Yeah, so Milo M was, about the same age. The child in that case was 12 years old. Of course, the age is relevant. Of all the sort of totality of circumstances that the courts have considered in threats cases, age is certainly very relevant, and the court certainly focused on the child's age. He drew these pictures that were very violent of himself pointing a gun at the teacher. So it was repeated. It wasn't just a single statement that as soon as the statement was made, he sort of realized, oops, that was probably not the right thing to say. But there was a drawing and then an intervention and then a second drawing provided to the teacher showing some level of, persistence. And then the teacher testified that she was apprehensive and afraid for her safety. There was a fact in Milo M that even though the juvenile had been suspended, he was still loitering near the teacher's car later that afternoon, which indicated some level of seriousness to what he said. It's just, I think the distinguishing factor of Milo M is that there was some persistence and it wasn't sort of in the heat of the moment of this off the cuff and then whoops, dialing it back, calm enough to walk to his locker and leave the building on his own. He didn't kick a locker as he walked through the hallways. He didn't make any physical gestures toward the assistant principal. He certainly didn't try to find the teacher who was the alleged target of the threat.
Another distinction with Milo M is that Milo M was looking at the sufficiency of the evidence. And here we're looking at the existence of probable cause. And one of the things that I'm struggling with is while I tend to incline in the direction that you suggest about blowing off steam, as your sister suggests, why is that not a question for a fact finder on a more fully developed record?
Right, so probable cause is certainly a low standard. However, as the Commonwealth points out, each element does have to be supported by probable cause. And the elements in this case include elements that are considerate of the true threat doctrine. I would point the court to, it's an unpublished opinion, but the Andrew Gunnis case from 2017 was a case that was, this court affirmed the allowance of a motion to dismiss for lack of probable cause, where a defendant actually said that he was going to, it was a defendant who had been taken into custody from a courtroom, and he told court officers that he was going to come back there with a gun. And then he repeated it. He said, I'm serious. I'm going to come back here with a gun with a vengeance. And the court found that even with that probable cause standard, there wasn't probable cause for a threat where the defendant's words were better seen as an angry outburst and not an expression of an intent to inflict a crime on another in circumstances that would justify apprehension.
Are you familiar with either Valentin V or Jordy G?
Yes.
Okay.
And I was just going to say something about Valentin V.
Okay, good.
Yeah.
What were you going to say?
So I recognize that Valentin v, the court in Valentin v really focused on probable cause being a very less exacting of a standard than the beyond a reasonable doubt cases. However, Valentin v was decided before Humberto H. and before a line of cases where the SJC has really authorized and encouraged juvenile judges to be particularly rigorous at the probable cause stage in light of the carry consequences for juveniles and the need to not sully a juvenile's record without really having to. So I think I think juvenile judges are in a different role now and play a different role, and probable cause is slightly different now than it was at the time of Valentin v. Valentin v is also really distinguishable on the facts. I mean, the result of that case depended in part on the fact that it was a high school student, not a 13-year-old boy. Valentin v and the other juvenile, Fred, the alleged victim, were both students under suspicion for stealing an Xbox. Fred was in the classroom, and then the juvenile tried to follow him out of the classroom, said that he was going to beat him up in front of the teacher and presumably other students.
But George is a 2018 case, and the juvenile was 12, making threats against his teacher. Do you know that case?
I actually don't. I don't for that reason, Your Honor. I'm familiar with it for another.
Okay, that's okay.
I'm happy to submit a letter on that issue, but
I have the case. That's fine.
yeah.
So you also make the argument that the Commonwealth didn't prove any of the elements, and didn't establish probable cause, of any of the elements, and we can affirm for any grounds apparent on the record. I just want to be clear, of the 5 elements, they didn't establish probable cause for any?
Well, I don't think so, Your Honor. I would say the elements really bleed together. I think as you look at the case law, it's a little muddled. I mean, it seems to me that the ability to carry out the crime sort of informs the reasonable apprehension, and reasonable apprehension informs the expression of intent to inflict a crime. I mean, so I guess I would say it's a little difficult to parse them out, because it seems to me that they all fold into the ultimate question of whether this was a serious expression of intent to harm.
And do you believe that the test is subjective or objective for fear?
I think it has to be both, Your Honor. I know the objective test is more commonly applied. It's the one that's reflected in the jury instructions. However, again, I don't think it's dicta when Shawley said that the threats statute was constitutional because it requires the Commonwealth to prove that the defendant caused the victim to fear harm. And again, that was reiterated in the construction of the criminal harassment statute in Bigelow and Johnson, and in the civil harassment statute in Van Loo and O'Brien. Each time a statute is challenged on constitutional grounds and construed, the court finds that the protected speech is not criminalized because it would only apply to direct threats or words or actions that cause the victim to fear harm. Again and again, that principle is reiterated. But again, I mean, I think even if subjective fear on the part of the teacher wasn't an element standing alone, it certainly informs the reasonableness and the objective test. And in this case, as Your Honor has pointed out, 4 days passed. I think, and I could be wrong too, but I think it was on a Thursday that the alleged threat was made, which means that there were 2 school days and then the 2 weekend days before the SRO. This is a school resource officer who was in the building. All the assistant principal had to do was walk down the hallway to tell the police officer if there was any real concern. And the fact that, the Commonwealth points to, well, during the 4 days, maybe they were taking other steps to address the juveniles if there were mental health issues or other issues going on, but there's no evidence in the record of that. So I would urge this court not to speculate about what might have been happening during those 4 days. What we do know—
And you are correct, it was a Thursday.
Thank you. But in any event, we do know that the juvenile the teacher in this case did not seek a 209A order, at least it's not in the police report. There's nothing in the police report about what
Oh,
happened.
she wouldn't have been eligible for a 209A.
I'm sorry,
right?
a 258, yeah, that's true. Or a civil harassment order or a stay away order or any, she didn't, there was no step by the teacher or the assistant principal or the principal to address the teacher's safety. In fact, it's not even clear that the teacher ever even did find out about the statement in this case. When she testified, when she told the police officer that she was weary and uncomfortable, my reading of the police report is that she may have been weary and uncomfortable because of the sort of misbehaving conduct that she reported to the assistant principal, the banging his fists and clenching his fists when she was trying to instruct him. It's really.
But I'm struggling between the sufficiency argument, which is sort of where your argument is heading, and what we have before us, which is, as everyone has acknowledged, the much lower standard of probable cause. I think it's a different conversation if we're talking sufficiency.
Sure. It is, Your Honor, but again, I would point to a case like Andrew Gunnis. I think there aren't that many cases because the facts in this case are just so, frankly, low level. I think this is the kind of thing that happens in a middle school every day. And it's not that the school couldn't have done anything. They certainly could have engaged some sort of threat assessment process to determine if this was a credible threat or not. A lot could have been done. Waiting 4 days and then sending this child into the juvenile justice system as an alleged delinquent was not the only way to go. It was not in line with the spirit of the Criminal Justice Reform Act, and it wasn't. It doesn't reflect that this was a true threat.
The 128 you're talking about is Andrew Goodness from 2017?
Yes.
Okay.
Yep.
Look, the criticism that you direct toward the decision may very well be well placed, but that's not the question that we have before us. The question is not whether this was an appropriate choice, but whether it was a permissible choice under the separation of powers and the decision that the prosecutor, that the DA's office made, right?
Right, but I think it informs. I think it's information that the court can rely on to determine whether the circumstances would create reasonable apprehension that a threat was going to be, that this was a threat. And I do think that the juvenile's specific intent, which really hasn't been the focus of many threats cases in Massachusetts, admittedly, but is very much a focus of other true threat cases. And again, cases like Bigelow and Chu, I think it's, and Walters. Walters was a case that really turned on the defendant's lack of specific intent to instill fear. And in that case, the conduct that was the basis of that complaint was really much more violent than the conduct in this case. It was a picture of holding a gun and saying, I'm going to bring, or I have the will to bring these idiots to justice. So I would just ask the court to focus on the juvenile specific intent in light of his age, where the Supreme Court has talked about juveniles' characteristic recklessness. His intent was much more likely to be sort of swagger, bluster, bravado than it was to intentionally instill fear in a person who was not even present when he spoke. I don't think that Troy T. rule about the presumption would apply. It's never been applied in a case where there's a 13-year-old who blurts something out in the heat of the moment. And where there's a conflict between the need, lack of a need for the threat to reach the intended target and the subjective fear that's been required in constitutional analyses of other statutes, I'd ask the court to apply the constitutional analysis in this case.
Thank you. The case is submitted. That concludes the argument. We will move to our next case.
We are live and on the record.
The next case on our list for hearing this morning is case number 2020 P0190, the Commonwealth versus Jean Lehens. And just as a reminder, we will be taking a brief recess after the conclusion of the argument in this matter. Attorney Garaci, you may begin.
Thank you. Good morning, Your Honors. May it please the court. I'm Michael Geraci for Jean Lehens. We are contesting the convictions on 3 of the 4 counts he was actually convicted on. And as was stated during trial, We think the entirety of the issues of merit hang on the intent of Mr. Lehan's, different forms depending upon the count. And I think the longest argument would be the first, having to do with his conviction for assault with intent to rape, where the intent requirement is a specific intent. And I do go into that a little bit, and we think that there simply isn't, despite the facts. And I'm not sanitizing the gentleman's behavior by any stretch, but nothing during the incident showed at the time of the attack he had a specific intent to do a rape. It's assault and battery behavior, and it may be other things too, but everything about it's like that. And so from the time when she come out of that bathroom, for example, with the bathrobe, he grabs her by the wrists and starts forcing her toward his room. And the only thing he said to her is, you want to talk to me. That's what I said. And when he got her in there, locks his door, throws her on the bed and gets on her. Right there, you've got three broad characteristics that appear to be similar to many cases where the courts have upheld specific intent. He grabs her against her will, throws her on the bed, and then gets on top of her. But that's superficially similar. Lots of cases have cited.
But how does he get her from the shower to his bedroom?
Force. Grabs her against her will by the wrist and starts forcing her down the hall into the bedroom.
They end up on his bed while she's in a towel with him on top of her.
Well, she's in a bathrobe with a towel underneath her. That's true.
Okay.
And he gets on top of her.
And you can't infer an intent from that, all of that?
I would suggest not. All his conduct during the struggle was nothing sexual, nothing, no words.
But Mr. Garasi, you are omitting from this narrative a good deal of prior interactions between the parties that provides context for his motivation and his objective.
It certainly does circumstantially. You're right. I spend a lot of time in the brief on all the prior behavior, and there's two lines of it. One is the sex stuff, where defendant toward victim, as well as the other roommate, had expressed multiply, verbally and by text messages, his interest in sexual engagement with them, and they of course had absolutely no interest in that and buffed him. What you don't see at all is in his conduct any sort of unconsented to behavior or crossing that line ever.
Until this moment. I mean, in the context of all of these repeated entreaties to engage in sexual activity with him, he lays in wait as she comes out of the bathroom in a shower and a towel, in a bathrobe and a towel, and pins her to the bed. And you're suggesting that his prior expression
up on me, Your Honor, if you can still hear me.
Yeah, can you still hear me?
Hold on, yeah.
Attorney Garasi?
He looks frozen.
Yeah, he's frozen.
Should stop the clock.
Yeah, Jake, let's stop the clock and let's go back into the waiting room and see if we can get him out and back in again. Jake, stop the clock, if you would. All right, and let's go back into the.
We are again live and on the record.
Okay, let's get the digital timer back up. We are continuing with argument in case number 2020 P190 after some technical difficulties. Attorney Garasi, the question I asked before we lost you is why doesn't that context of prior repeated expressions of interest in sexual activity with both the victim and the other roommate bear on the defendant's intent at the time that he grabs her and forcibly puts her on the bed while she's in a bathrobe and a towel?
Well, that's fair, but I think the right answer is all that stuff preceded the attack. The last text message was about 9 days beforehand. Secondly, during the attack, there's really nothing sexual going on there. It's more or less violence. In addition, you have a second line of behavior involving both defendant and the two roommates, having to do with them disobeying his rules and being contemptuous of him and all that got him really angry. So the Commonwealth's obligation is to show that during the attack he had a specific intent to rape, whereas there aren't any facts there that would suggest that. If you look at all the cases where a man grabs a woman, throws her down, gets on her, it's additional stuff, like he ripped her clothing off or removed her slip.
Well, but she was already in a towel and a bathrobe. So if we're looking at this in the light most favorable to the Commonwealth, which we're required to do on a sufficiency argument, I'm having trouble. You're isolating incidents, but we have to look at it in the totality of the circumstances, right? And you agree that the assault and battery was an intentional touching?
Sure, he was intending to do assault and battery on her. I agree with that. It's just that.
And so when he touched her breast, that was an accident?
I would say it was inadvertent, and I think the judge didn't quibble with that. He also saw it as being during the struggle. The victim.
Well, but he didn't enter a not guilty, right? He was the fact finder.
That's because his reasoning, as I argued, was older under Edgerton. He was thinking in terms of indecent A and B being a general intent. Was arguing under Marzilli that the defendant needs a conscious purpose or intent to do the indecent touching, and that's really not there. The judge's analogy about a person who tries to save someone's life from getting run over by a car inadvertently touches the breast isn't this case because he's actually doing some illicit conduct to her, assault and battery. But the inadvertence about him shoving her on the bed is when he touched her breast over the bathrobe. He's still under Marzilli. There's still no conscious purpose to do that act there, Your Honor. And consider the fact that she had a towel on and a bathrobe, and the towel came loose. She's naked under the bathrobe. He had her thoroughly pinned on the bed. Nothing out of his mouth or nothing about his physical behavior suggested he was trying to get under the bathrobe, open the bathrobe. He had all kinds of opportunity to do it. There was nothing that interfered with that. Case law.
But she didn't say he was striking her or slapping her or in some way punching her. She said he had his hands all over her body. He was touching her all over, including her.
Right.
So that's a little different than punching or slapping or an act of violence. He was touching her. He was touching her body all over.
Well, I agree. He wasn't doing that, Your Honor. The facts suggest he's throwing her on the bed, getting on top of her, and yelling at her, "Who's the man now?" And he's angry for something, but there's nothing there. He had plenty of opportunity to do something sexual, and he didn't.
Well, no, he was in the early stages. She eventually was able to escape when she got his hand free from her throat and jumped off the bed. But the reason this is an intent to rape as opposed to an actual rape is that she was able to escape.
Well, my reading of the facts is after she said she couldn't breathe, he asked her, "Do you have a medical condition?" She said yes, and then he released her. She didn't forcibly get it off her.
I don't know if he released her. He lightened up on his grip or pressure, and she was able to get away. Mm-hmm. So there's a difference between I don't think it's read that he stood up and let her go.
No, I didn't suggest that, Your Honor. I am suggesting that
once the grip or it says forehand. I'm not sure if they meant the back of her hand or her forearm, but once that was lightened up, she was able to get up herself, not so much being released by him. And then the struggle ensued. She was holding on to the window. The window actually shattered. It's not as though he released her. So,
well, I'm not disagreeing with that, but and you may be right about the release issue, but he didn't grab and squeeze her throat. He was pinning her down as she was testifying, and he did let go of her throat.
No, but we started down this entire line of discussion in my pushback against your suggestion that he had ample opportunity to engage in sexual conduct toward her in this encounter. And my suggestion is that if we look at the sequence of events, the reason why it didn't progress to that stage was because she was able to escape from his grasp before it progressed to that stage, or at least a reasonable fact finder could infer that based on their prior interactions.
I would have to respectfully disagree, Your Honor.
Well, we can disagree.
Yeah, but everything about it suggests that he was doing violence. He was pinning her down. He's yelling at her. Nothing about his hands going under the bathrobe toward it, trying to even open it. We don't even know how long it lasted, by the way, to be honest with you, the time lapse. But my argument is, if we're going to jump to some specific intent to do an actual rape, you got to do speculation there. It's just not there. Whereas there is an alternative motive as well. The case law is often noted. The absence of an alternative motive is interesting and not helpful for the defendant, but it is for the Commonwealth. And he's got a grudge against the victim as well as her roommate, which they had a major blowout just before, perhaps maybe under 2 weeks before the actual attack occurred, where the roommate left. And
Do you acknowledge that rape is a crime of violence?
I don't know if it is or not. It may be.
I'm sorry. Are you questioning? Rape is a crime of violence, right?
It may be, Your Honor. I don't know. I'm trying to focus on the elements of the offense.
Okay, I'll leave it at that. If we don't have common ground on that question, I'm not sure what else I can ask.
Well, the rape itself, though, Your Honor, is a general intent crime, but the crime here, assault with intent to rape, is specific intent, and so every case I've cited before you, the court deals with facts that are part of the attack, where there's pretty much, solid information to draw that inference. All you've got here is that he's attacking her and throwing her down, getting on top of her, and nothing is there to thwart him. There's no other people in the house. So what information other than that, the attack, can be used to draw an intent to do, an unconsented to penetrative act? Okay. Similar arguments, though, with other offenses. The strangulation argument, the only element we're disputing here or arguing about is the third element, where the defendant has to have intended to interfere with the breathing of the victim. So he throws her on the bed, and so when he gets on top of her, he doesn't grab her throat. He doesn't put his fingers on her throat and press. He doesn't do anything like that. And I've got cases in contrast, like Grogan, for example, where a man puts his hands around a child's neck, with the thumbs in the front throat area. It was clear that he was, trying to basically choke or strangle her. Whereas here, he's got his hand or arm or something pinning her down on the bed, and those facts suggest he's trying to pin her down on the bed, not necessarily interfere with the breathing. It's clear he put his hand or arms on her neck. It's clear that her breathing was interfered with, and without any right of excuse, as the law says, but it's not substantiated that he had an intent to do that to her. That is to interfere with the breathing, and it's primarily because of how he put his hands or arm on her neck area. And then later, when she said she couldn't breathe, he starts asking her, do you have a medical condition? Why would he do that if he was trying to strangle her? And then she said yes, and that's when he, again, let go of her neck. If he had an intent to do a strangulation or a choking or what have you, those facts don't seem to make sense. He's just doing assault and battery. He's subduing her, and he's yelling at her.
In that argument, what do we make of the fact that your client had a visible and bloodied bite mark injury that was consistent with the victim's testimony of trying to get him to let go of her throat?
Sure. The bite marks, as I understand the facts, came after she got off the bed, went to the window, and he put his hands over her mouth, where she then bit him. Not while they were struggling on the bed and his hand or arm was on her neck, Your Honor.
So what was his intention putting his hand over her mouth?
I would suggest he was trying to prevent her from screaming for help. She went to the window, she said, to yell for help. He didn't put her on her neck, it was just over her mouth, and that's where she bit him. That was like after the event on the bed.
And the injuries that she sustained that were actually increasing consistently with bruising 2 days later, what are those consistent with?
Well, his hand or arm on her neck, perhaps.
The ones on her thighs?
Sorry?
The ones on her thighs?
I don't know about that. I know she talked about some bruising. I don't know how deep that information was. I wouldn't say
Dark
it's related
patches
to the-
on her thighs.
Mhm.
And she still had them 2 days later, and a dark patch on the back of her arm.
Okay, that's all a byproduct of the struggle and the violence he was doing to her, wouldn't it be? But that, I don't think that goes to strangling. I mean, I think I've got a difficult argument here just because the facts are terrible. I'm not trying to sanitize his conduct in any way, but just honing in on intent. Where are the facts that show he intended to interfere with her breathing as opposed to he just intended to do assault and battery? I mean, I don't know why he didn't get charged with kidnapping, by wrongly restraining her movement and so forth. But the strangling, I think the facts really they're not there to show beyond a reasonable doubt that that's what his intent was. I'd say the same for indecent assault and battery. That one, I have argued, I hope I wasn't overly bold, that the crime under the Marzilli case is a specific intent crime as it relates to element 2. So it's unlike the older case law, Edgerton, where it's really general intent, where the focus seems to be on element 1. So let's say he intended to do an assault and battery. I think the facts suggest that the touching of the
I
breast.
think we have it, Attorney Garaz. We see that your time has expired, so we'll leave it there.
All right, Your Honors. Well, thank you, and thanks for your patience about my computer.
Okay, thank you. Thank you for your patience as well. Attorney Black for the Commonwealth.
Thank you, Your Honor. ADA Johanna Black for the Commonwealth. I think what I'll just touch on very briefly is the argument with respect to the defendant's indecent assault and battery on the victim. The Commonwealth states it in its brief, but just to reiterate, all of the evidence that supports the defendant's intent to rape the victim is also evidence of his intent to touch her breast, to touch an area of her body that is private and commonly associated with an indecent touching. I also think that, as stated in the Commonwealth's brief, the Commonwealth will submit to the court that his prior behavior towards the victim, including trying to make conversation with her while he's wearing a Speedo that exposes the outline of his penis, especially she indicated on one time that he had what she believed to be an erection. That is indecent conduct towards her. The fact that he's trying to make conversation with her, that he's lingering around her, that he knows he's wearing a Speedo, a tight Speedo, that shows that he intended that indecent behavior towards her, that indecent conduct towards her. And I think that that prior bad act, as the Commonwealth submits in its brief, is suggestive of his intent on the time of this incident when he touched her breast. It indicates that he intended to touch her breast. Moreover, the testimony that came from her about how he was pinning her wrists, that he was pinning her to the bed, he actually admits in his testimony that it's still holding onto her wrist as she's struggling against him. But the fact that she says his hands are all over her body, just like Justice Lemire referred to during the defendant's argument, it wasn't that he was slapping her or punching her. The way she describes the contact is a touching, an indecent touching. His hands are all over her body while she's practically exposed. Her private parts are practically exposed as the clothing that she's wearing, the towel and the robe, are coming off of her body. And that, in the context being on his bed in his bedroom, his position over her, which she describes as a sexual position, all of that shows his intent was to touch her breasts, which are a private area, and that is an indecent touching. So he intended to touch and to make indecent contact with her breasts.
Would you address the strangulation? Would you address the strangulation and whether or not there was sufficient evidence to indicate that it was an intentional act to affect her breathing? In other words, why wasn't it part of the struggle to just hold her down and not just an inadvertent position that he had her in as compared to a conscious attempt to block her breathing or affect her breathing?
Sure. I would submit that, as referenced in the brief, the pressure to her neck was substantial pressure. Rather than using that hand, that forehand, as she described it, I believe, but using that hand to hold other parts of her body. He chose to place it on her neck. And the way she describes the pressure as substantial pressure for a certain period of time suggests that it wasn't accidental, that he chose to place his body part on that part of her body. And it's just another means of preventing her resistance to his attempts to touch her and to rape her.
Does he need to have the objective, the intent of causing strangulation, or is it sufficient that that his intent be to apply pressure to her neck, which has the effect of strangulation, even if that was not his objective?
I want to double check my brief, but my understanding is strangulation is a general intent crime, that there's not a specific intent. But let me, if you don't mind, I just want to double check the citation.
I think there has to be an intent to interfere with the victim's breathing.
I'm sorry. Yes. Right. So
just
I understand your question.
Holding her down, just using his arm to hold her down, to restrain her so he can theoretically either rape her or touch her. Is that sufficient without a conscious effort to interfere with her breathing?
Well, with the so I don't think that's sufficient, that he needs to, I agree with Your Honor that he needs to interfere with her normal breathing. The facts that he initially grabs her and tries to take hold of her as she's coming out of the bathroom, and she immediately resists him, and she's fighting him all the way back to his bedroom and onto his bed, and she continues to try to resist him as he's still trying to grab her, touch her, hold her down. Earlier, he was trying to push her towards the bedroom and onto the bed. The Commonwealth submits that where the evidence shows that she's resisting his initial attempts to subdue her or to contain her, that his movement of his hand or his forearm to her neck and his substantial pressure is another attempt by him to prevent her from resisting, that his prior efforts—
Prevent her from resisting, yes, but when he releases his arm from her throat, when she tells him that he can't breathe, doesn't that tend to augur against the suggestion that he was his purpose was to cause her to stop breathing?
The Commonwealth doesn't argue that he intended to stop her breathing. The Commonwealth's position is that when his efforts by just holding her and pushing her and grabbing her and shoving her and holding her down weren't successful, that she was still able to resist him and he wasn't able to perform the penetration, that he then ups it to trying to interfere with her breathing. When he learns, when she claims that she can't breathe at all, he backs off. He doesn't remove his forearm. He just lessens the pressure, which suggests that he did intend to interfere with the breathing, that it was another attempt by him to subdue her on the bed, but that he didn't want to stop her breathing. He didn't want to kill her. So when she says she cannot breathe, he, as she testified to, releases some of the pressure, but he doesn't stop. He doesn't pull away completely. She actually, when he lessens the pressure, she's able to push him off of her. So I
think you're conflating subdue and restrain her with interfere with her breathing.
It's an attempt to subdue. It's another means of subduing and preventing her resisting. The grabbing, the pushing. Sorry.
And so I understand the argument that you're saying that it is a different form, but the interference with her breathing was part and parcel of that effort
to prevent her from resisting it. Right. That's correct. Not to kill her, not to stop her breathing, but to make it more difficult for her to resist him, because she was resisting him all of the way from the bathroom onto the bed. He still hadn't been able to penetrate her. And this was just another different type of effort, another attempt to try to prevent her resistance enough so that he could perform the act. And I think with that, I'll just rest on the Commonwealth's brief if you don't have any other questions.
Seeing none, that will conclude the argument in this case. The case is submitted, and we will, as previously announced, take a 15-minute recess. We will resume at 10 minutes past 11.
Thank you, Your Honors.
Thank you.
Parts. The first being that the trial court failed to prove by clear and convincing evidence, DCF failed to prove by clear and convincing evidence that there was a nexus between mother's use of alcohol and her inability to safely parent her child, supporting the termination of her parental rights. And secondly, we are asking this court, and arriving at its decision, to consider a de novo review of the evidence, because the conclusions and factual findings of the trial judge were based largely on documentary evidence, and they do not reflect an even-handed assessment of all the evidence, and they are largely unsupported by competent evidence. And I will start with our request that this court review the evidence de novo. We cited-
That's a rather extraordinary suggestion, I have to say.
Yes, sir. And I would be happy to explain our position in requesting it and give a couple of concrete examples for you to ponder and whether or not you feel it's appropriate. So DCF points out in its brief arguing against a de novo review that the Supreme Judicial Court of Massachusetts revised its decision in Commonwealth versus Tremblay at 480 Mass 645 in 2018. I did only cite the appeals court decision. However, that decision from the Supreme Court actually further supports our request, and their premise is in one sentence. It says in that decision, we reaffirm the longstanding principle that an appellate court may independently review documentary evidence, but should accept subsidiary findings based on oral testimony, partly or whole, unless that testimony is erroneous. And I submit without reviewing it, you can't determine whether or not it was erroneous. And in that Supreme Judicial Court decision, they actually remanded the case back to the trial judge to carefully look at all the evidence, because they found that his conclusions from a videotape were clearly erroneous. It was someone who was, it was a motion to suppress. The gentleman was on video. The appeals court looked at the video and determined, unlike the trial judge, that the person was lucid and that the judge was erroneous in his review of what they call documentary evidence. And I would like to give one quick example of why we should call into question the reliability of the trial judge's perspective and review of evidence as being inaccurate. For example, in DCF's brief at page 14, they state that the grandfather was charged with child endangerment. 51A was filed by DCF when mother's father was caring for Lena and left the child in a car for a few minutes. And DCF says in their brief, grandfather was charged with child endangerment, and they cited the trial court's finding of fact number 37, which was actually 27. It was a mistake on page 9. And it states in the judge's finding of fact that on May 27, 2016, the 51A was filed over grandfather leaving the child. And it states, and maternal grandfather was also charged with child endangerment. That's simply false. And the trial judge cited exhibits 1, 22, and 23. 22 was a 51A, and in it, the social worker put in there, the grandfather is going to be charged with child endangerment. That never happened, ever. It was completely inaccurate.
But what you're arguing, it seems to me, is classic argument on clear error. When you have official records that demonstrate that a particular finding of fact is incorrect in some particular, then it is always the prerogative of a reviewing court to set aside that finding on clear error. The notion that the existence of that clear error based on documentary evidence, that we should then open our review of all of the findings for a de novo review is, I think, not only unprecedented, but untenable.
Well, I'm just going by what the Supreme Judicial Court said in Tremblay, which is that the appeals court has a longstanding history of reviewing all the documentary evidence, de novo on its own to see if you have the same perspective, and reviewing findings and conclusions based on oral testimony, whether if that is based wholly or partly on oral testimony, if those findings are erroneous. And
yes, but that's clearly erroneous. We do not undertake de novo review of any findings that rest in whole or in part on oral testimony.
Unless erroneous, according to the Supreme Judicial Court.
That's clearly erroneous. I mean, that's the traditional standard. It's not. We do not use an error in a documentary documentary-based finding to then conduct de novo review of findings based on oral testimony in whole or in part.
Yes, and I understand that.
Okay.
And we're asking you to do it within the parameters of the holding of Tremblay. I'd like to give another example that I think.
Well, but I want to push back a little bit more on that, because the SJC at page 654 to 655 of Tremblay said, an appellate court may only independently review findings that are based entirely on documentary evidence. And as your brother representing the department puts forward in his brief at page 40, here we have findings from documentary evidence, and there is independent testimonial evidence. So I respectfully, I think you're misreading Tremblay, the SJC's decision, which put a fine point on the appeals court decision on Tremblay when they took it on further appellate review. I think the argument is misplaced.
I do agree that if the judge's finding of fact and or conclusion of law is based on oral testimony, that the appeals court needs to give deference to that oral testimony. But if there is documentary evidence as well, and which may contradict that judge's finding, just as in Tremblay, they looked at the video the wrong way, that this court can have its own take on what that represents.
But that's on clear error. It's not de novo.
Well, I will, submit to this court's characterization of the review as being clear error. And we just feel that the way that the trial court characterized the evidence, documentary evidence in this case, has an incorrect perspective. I just would like to give one more example if I could. DCF acknowledges in their brief on page 52 that when the mother argued, the trial court mistakenly stated she had a criminal history beginning in Massachusetts, beginning in 2014 and continuing through 2018. We note that there was a 2014 criminal matter that was dismissed, and then 4 years later in 2018, the DUI, which triggered everything in this case. DCF acknowledges the court imprecisely described the mother's record. So we're asking the court to be aware of the—
But he went on to say the factual underpinning of the conclusion is accurate. So there are a tremendous amount of findings, right, in this case. I don't remember the exact number off the top of my head. So if we were to excise the findings that you've just identified, there's 213 total findings. If we exercise those that you've just identified, is it your view that there was not clear and convincing evidence of her unfitness to warrant termination?
Yes, absolutely. And that's the second phase of our argument. But that's interesting you bring that up, Your Honor. When DCF says the factual underpinnings of these conclusions are accurate, I actually have no idea what that means, because it says it was not in 2014, a case was dismissed, and in 2018, there is an isolated DUI, and there's this long-standing criminal history. What's the factual underpinning? I think it's a red herring, or it's a non sequitur, if nothing else. Okay, so moving on, the second part of our argument, unless you have any more questions regarding de novo review, at the very least, we would ask the court to pay careful attention to what the documentary evidence actually reflects in this case. our argument regarding failure to substantiate the termination of parental rights goes to a lack of nexus between mother's alleged abuse of alcohol or use of alcohol and endangerment of her child, a lack of ability to parent her child in this case. We are arguing that there was no nexus shown of all the evidence at the time of trial that she was presently unfit to parent her daughter. And we cite Catherine for the proposition that the judge's findings do not reflect a history of negligent or abusive care of the daughter, Catherine. Quote, the parents' cocaine habit, standing alone, do not provide any indicia that Catherine's parents had provided anything less than minimally acceptable care. Now, how did we get here? The mother originally dropped off the child to the biological father in 2016. She did not have her son with her. She made arrangements that earlier that day for him to stay at a friend's house. She dropped the child off and drove away. There is hearsay in a document stating that a neighbor called the police, saw her drop her off, and thought she staggered away. And that is hearsay. This is how the whole case started. The biological father, who clearly wanted nothing to do with the child, never attended any proceedings, did not testify at trial. So that means that every single thing attributed to what this biological father may have said about mother is pure hearsay. He ends up calling the police. I don't want anything to do with this baby. She's taken to the hospital. DCF files a 51A. Mother gets the child back that week. That night, within a few hours, DCF is at mother's house. She was sober. Her house was clean. They interviewed the son where she said he was going to be, and nothing was found. And that is how this case started. And that's where we are. And that incident is referred to dozens of times throughout the findings of fact and conclusions of law as starting this history of child endangerment. Well,
wasn't there some evidence of the baby's failure to thrive when it was taken to the hospital?
Okay, so there was one anecdotal statement in a hospital record when they brought this child to the emergency room. Okay, so we don't know how many hours elapsed from the time she's at the father's house. The police are called. We know she's transported to the hospital. This is an infant. So over a few hours, that could traumatize a child by the time, but we don't know by the time she got to the hospital. But what I took care to go through those medical records and point out that this was a very tiny, petite child. Throughout this case, failure to thrive was, I admit that's actually wrong. They struggle with weight gain with this child. It's in the medical records. We cited in the record, and mother worked with the pediatricians and made every appointment of special formulas for weight gain, things like that. So the emergency room doctor, who's not familiar with this child, made this, she's borderline dehydrated. That can actually occur, as we all know, given this acute trauma just from being at the father's house, police being called, the lights being flashed. We don't know what but what we do know is within a few days of this happening, that child is back in mother's care. So we know that there was nothing that the court found that was so traumatic to that child from mother that she was not given the child back within days. They did not keep the child from her. That's how the case started. This case is, if I could put one word on this case, it would be the word relapse. The word relapse. So we are asking the court to look at, does every parent who who has a DUI and who suffers with their use of alcohol, here it wasn't drugs, she had isolated use of drugs. She had, I think, one cocaine use, she used marijuana in the beginning of her pregnancy, and then that stopped, and there was nothing more during her entire pregnancy. And then she got a DUI in 2018. And that kept her in the system. And from that day forward, she struggled with DCF. She had an attitude with DCF. They didn't like it. She would not, when they said jump, she should have said how high. That didn't happen. They didn't get along. We concede that. She didn't give them the information they wanted all the time. We concede that. The judge found that she didn't do that. All of that is true. But what we keep coming back to, no one's talking about the child. we're propositioning that the trial judge did not conduct an even-handed assessment of the evidence. Everything about this was attacking the mother, as a person, her reputation, what she didn't do, not what she did, not the fact that she parented her son. He was 12 or 14 when this happened without a problem. Although the father, appellate attorney, makes a statement in his brief that the father of the son made some comment to some social worker that got in the record that, he was always worried about her drinking and drugs ever since the son was born. Really? Well, why
Ms.
didn't
Kiefer, I see that your time has come to an end. We'll have to leave it there. Thank you.
Sure. Thank you very much.
Okay, for the department.
Good morning. My name is Tim McLaughlin, and I represent appellee the Department of Children and Family. For the third time in as many years, at her second review and redetermination hearing in September and October 2019, mother was determined to be unfit to parent her child. At her first review and redetermination hearing in January 2019, mother was determined to be unfit, but the juvenile court there found that there was not sufficient evidence of mother's continued use of alcohol in the review period. Mother did not appeal those findings and accordingly did not contest her unfitness through January 2019. Accordingly, DCF's burden at the second review and redetermination, which is the hearing that's under review here, was to provide clear and convincing evidence that mother continued to be unfit and that mother had failed to address her substance abuse issues. Now, mother knew what she had to do for the department to support mother's parental rights and or reunification after the January 2019 hearing. She had a number of service plans with DCF that listed certain things that she was expected to do. She was expected to refrain from substance abuse, namely in her case, alcohol. We have her own testimony at the hearing under review that at least twice in the period under review that she relapsed. She was to provide her communications with DCF, or her communications rather, with therapists and other providers with DCF. She failed to do that. She was to obtain a sponsor through Alcoholics Anonymous. She withheld proof from DCF whether she had such a sponsor. She was to, relatedly, attend and provide proof of attendance at AA meetings. She provided some proof of meetings in March and April 2019, but then did not provide any evidence from May 2019 through the hearing in October 2019 that she was attending AA meetings. And finally, she was also to provide a relapse prevention plan, showing the steps that she was taking to avoid relapsing on alcohol. Again, she did not do that. So I think it is important to recall that while mother does have a history with the department and with alcohol, that what is truly under review here is whether mother took steps between January 2019 and this hearing in September and October 2019 to address the identified deficiencies. The department submits that she has not, and the juvenile court agreed that she has not taken those steps.
Can I ask you, apart from what you set forward in your brief about Tremblay, do you want to further respond to anything that Ms. Kiefer said today?
I would briefly, Your Honor. I think the one thing that's important about Tremblay is how distinct the facts were in that matter from our matter. In that case, the judge, the appellate court was reviewing a videotaped suppression. There was truly only one piece of evidence, and the appellate court was in the same position as the trial court to review that piece of evidence. Here, we're looking at the third hearing involving mother. The hearing involved 7 witnesses, 3 days of testimony, and a number of exhibits, as mother notes, but a number of those exhibits were, context was provided by witnesses. And in this case, there truly were very rare instances of exclusively documentary evidence that this court would properly review de novo under Tremblay.
Thank you.
That would bring me to my next point, which is that mother raises that there's not the nexus required under adoption of Catherine to support the finding of unfitness and parental termination in this case. Now, again, I would note that mother was determined to be unfit. as of January 2019, she did not appeal that finding, so that finding is indeed binding. But in any event, if as the SJC has said, earlier hearings, it's not a blank slate for the trial court. And this trial court properly did look back to instances prior to January 2019, where child was endangered by mother's substance abuse. We have the July 4th, 2016 incident where the child was left at the home of her putative father, where father was not prepared to care for the child. And where, as Your Honor notes, the child was subsequently brought to the hospital where various physical issues were identified. And then we also have the September 2017 incident where DCF made an unannounced visit to mother's home, and it was revealed, and mother fled upon the arrival of the DCF employee, and mother left child in her intoxicated either boyfriend or roommate's care. So I do think there is evidence here, again, of the child being put in harm's way, and that matter has been litigated and it was adjudicated in January 2019 at the first review and redetermination. I would ask this court to focus on what the evidence shows between January 2019 and October 2019. And we have both documents and we have witness testimony to the effect that during the period under review, on 4 separate occasions, mother violated her probation by having positive scram tests showing that she had used alcohol. And mother's own testimony, when she was testifying on October 15th, 2019, is that at least on 2 occasions, she admits that she relapsed on alcohol. And then we have just the more general throughout the period under review. We have mother's failure to comply with the service plan, mother's failure to take those steps that DCF properly identified as trying to help mother with her substance abuse issues. So we have mother not attending AA and not providing any details about her therapy sessions, and in a number of other instances where mother simply was not taking the steps that she should have. The one final thing I would just address in response to my mother's discussion of grandfather and great-grandfather's reports is that we do believe that there is evidence supporting grandfather's unfitness, and the 51A allegations were substantiated against him, or at least made against him. And that's at the record of volume 2, pages 188 and 194, where the allegations against grandfather are stated to be upheld and substantiated. But again, the department submits that this is another instance of pre-January 2019 conduct that truly doesn't have a bearing on whether mother continued to be unfit to parent this child, and whether parental rights should have been terminated. Seeing that my time is almost up, DCF would simply ask that the court uphold the trial court's findings in all respects. Thank you.
Thank you. Okay, who's next? Attorney Cohen, I have before you get started, I guess my threshold question is, why are you in this appeal?
Because father is an appellee and wants to support.
How is father an appellee? Father's parental rights were terminated and he elected not to appeal that decree. So how is he an appellee?
Because he wishes to be heard on
Well, lots of people could wish to be heard, but what is his stake in the matter? In my prior career as a real estate attorney or as a land court judge, we used to call this standing. Sure. I am at a loss to understand under any procedural rule what proper role the father has as an appellee in this case. The fact that he was adjudicated unfit and that decree became final when he elected to waive his appeal is even further reason to question why he has any entitlement to be heard on the question of the mother's rights.
Well, I would maybe partially correct Your Honor on that. So that was an issue where father had been supporting throughout this trial. Father supported the termination of mother's parental rights and had made it clear to the juvenile court that the father was basically in a backup position if the court did not terminate mother's parental rights and DCF could not find suitable adoptive parents. And that had been discussed throughout the case, is my understanding. And so the court—
Wait a minute, I don't understand that. What do you mean he was in a backup position? He was adjudicated unfit and his parental rights were terminated.
And then that was undone and done voluntarily by stipulation. In other words, there was a decree in December 30th, 2019, where the court basically did it involuntarily, and then father went back and said, no, you understand that I wanted to stipulate to that. And father, so that was, the judgment was amended, and this is February 25th, 2020. The court amended the judgment, allowed the father to come back in, stipulate voluntarily, stipulate determination of parental rights, sign an open adoption agreement. So then
he's out of the case.
Well, he waived his appellate rights,
right?
But I don't see how that waives his right to be heard here, Your Honor.
He has no interest in any matter remaining for adjudication once he's out of the case. No cognizable legal interest.
Father does not see it that way. I mean, the court accepted.
Why don't you? Well, you have 14 seconds left. What cognizable legal interest do you contend the father has that is enforceable or susceptible of our review?
Well, if I may, Your Honor, because I will research this, and if I may be permitted to submit a case site, I don't have one at hand for you. But father did not waive his appellate rights to be heard on the adjudication. And
I guess we'll have to leave it there. Thank you. Okay, for the child. The child, I recognize, has an interest.
Absolutely, Your Honor. The child, it remains in the pre-adoptive home where she entered back in February 2019. She is now 5 years of age, ready for kindergarten in the fall, and she's doing well in the pre-adoptive home, as was indicated in the judge's decision. I think that mother has a long history, even back in Virginia, with alcohol, and consistently on throughout this case. And she was involved, just to correct the record, with marijuana for a second time. Not that marijuana is her primary substance of use, but that there was a second time where she was tested. There was a 51A at birth of the child where marijuana was detected. And also then in August of 2016, when she had regained custody after the initial removal, she lost custody again because she violated the terms of the court's conditional order of custody. And one of the reasons that she was found to have violated the court's order on conditional custody was because she tested positive for marijuana. But her involvement with alcohol was very much more substantial and continued over a long period of time. And the fact that she didn't take significant measures over that long period of time to address her alcohol problems was held in adoption of Luke to be a significant factor, in as much as if it's the case at the same time that the alcoholism involvement was undermining her ability to deliver proper care. And I think that, yes, it was undermining her ability to deliver proper care, as we saw in the failure to thrive diagnosis that was made at Cape Cod Hospital when she was taken there and I wouldn't place any weight on the notion that, well, these emergency room doctors had not seen this child before. She was found to be both malnourished and partially dehydrated, and to be expressing a failure to thrive condition. Yes, true, she was relatively petite, and later on had some issues with weight gain, but that's based on the foundation of having been a failure to thrive child at the age of 3 months. And that was something that occurred while she was in mother's sole custody, indicating that the alcoholism and the poor care coexisted. This was also found to be the case when there was the unannounced visit, and mother was found to have appeared to be inebriated and to have given over partial caretaking to a man who was himself noted to be involved, to be inebriated at the time. Then mother, according to her son, she, according to the DCF record, he reported that she was on her way to pick up the child, in this case, the young girl, when she was stopped by the state trooper in the snowstorm on Route 3 and found by this and clearly shown to be very inebriated at that time, driving well in excess of the speed limit in snow and wind on the highway. So she, in fact, was on her way, according to that other child, to pick up the young child, the 1.5-year-old at that time. And
thank you, Attorney Spratt. I see that your time has come to an end as well. So we'll have to leave it there. We have your briefs for whatever we did not reach. Thank you all. The case is submitted.
Thank you very much.
Thank you.
We are live and on the record.
That brings us to the last case we have on our list for hearing this morning, case number 2020P520. Excuse me, Richard Sarabian and others versus American European Insurance Co. and others. Mr. Tomlinson, you may begin.
Thank you, Mr. Chief Justice. Madam Justice Blake and Mr. Justice Lemire, good morning. May it please the court, my name is Ray Tomlinson. I am counsel for the appellants Richard Sarabian and his brother Stephen Sarabian and the Richard Sarabian Irrevocable Trust, which owns title to the real property at issue at all times relevant here too. The business known as Sertan Manufacturing Corp., which is a leather goods store operated by the brothers Sarabian, and the real property, mixed-use real property, was commercially insured by American European Insurance Company, appellee in this case. Your Honors, this concerns, I won't belabor the factual history, but Sertan has been in business since 1966. The past 20 plus years or so have been in South Yarmouth on Cape Cod. In 2016, there was a fire of a non-suspicious origin, which essentially resulted in a total loss to the real property as well as to the business and its inventory.
Attorney Tomlinson, I'm going to interrupt you early because I do have a bunch of questions, and
yes,
we are familiar with the factual background. In terms of, maybe I could start at the end. What is the current status of the business? Has it gone out? Is it still viable?
The business is hanging on to its very existence by threads.
So nothing has changed since the Judge Canoni's denial of the motion for a modified PI?
That's not correct. That's not correct, Your Honor. Last month, foreclosure proceedings have begun with a complaint in the land court under the Service Members Relief Act. So the lender is proceeding to foreclose after the moratorium lifted under the COVID pandemic.
Does that affect our review at all? The changed circumstances of your client's business?
I believe it does and it doesn't. I believe that's a loaded question. Respectfully, the circumstances of the business are that it has lost a tremendous amount of goodwill that it will never recover. Its very existence hangs by a thread now that the moratorium has lifted. They are in currently renting a retail space of which they're behind on their rent. They're over $100,000 behind on their mortgage. Foreclosure is starting. The imminence of the irreparable harm in terms of the lost goodwill is an unchanged circumstance. The new changed circumstance as Your Honor points out, is the fact that there are now foreclosure proceedings against the property. Interestingly, if the Sarabians and the trust, which holds title to the property, if the trust is unable to preserve the property by way of the injunction, then the very counterclaim on which American European rests, which is the ability to be able to recoup any payments that they make under the policy, for which ultimately they are held to not be liable, or there's no indemnity obligation.
How is recoupment a realistic prospect given the financial difficulties you just described?
Thank you, Your Honor. That's exactly my point, is that if the building is lost and all the inventory that's been looted and rotted away due to mildew and mold, even if the policy provided for recoupment, which it does not, there is no likelihood of any recoupment.
I'm not talking about I'm talking about if you are paid money that is later adjudicated not to be due,
Yes,
how will the insurer recover that money from a party that is from an insured that is insolvent?
Valid question. Two answers to that. The first is that if the court awards if the court orders the insurance company to specifically perform its contractual obligation to pay a claim that it never disputed and approved for payment more than 4 years ago, the insured is going to place that money, pay it into court, and hold it as escrow while it hopefully resolves the unpaid mortgage and stop the foreclosure on the property. Your Honors, without the property, that asset is lost forever, and that is quite frankly an asset that is necessary to preserve the status quo.
Well, but let me also go back. One other structural question, and I know Justice Blake has a number of questions for you, but one overarching question I have about this entire case is how it is that the injuries are not of a sort that are compensable by money damages. Even the loss of the business in its entirety is of the type that we routinely see in civil matters that are compensated by money damages. And in this case, if you are correct and there's a violation of 176D, those money damages would be subject to multiplication. So I am at a loss to understand how the original order requiring payment of proceeds before final adjudication was warranted by irreparable harm outside of money that was not compensable by money damages.
Thank you, Your Honor. The case law is replete with examples of how loss of goodwill is not compensable by money damages. The loss of trade relationships and customers created over decades of a relationship, and the inability to be able to buy wholesale stock, be able to preserve and maintain those relationships because of being forced into needless adversarial litigation over claims that should have been paid and were never disputed. That's the very benefit of the policy that the insurance company contracted to pay, and it's the very benefit underlying the statutory scheme that protects both insureds and insurers. The loss of goodwill, Your Honor, respectfully, is not compensable by money damages, and it's incalculable in the injury. As noted in Mr. Stephen Sarabian's affidavit, they have lost the ability because of their inability to fabricate and manufacture at their location, which is burned by fire. They're not able to supply their customers with goods that has damaged that relationship beyond repair. Those customers have not come back. Repeatedly, customers come in and essentially accuse them of being participants in some kind of fraud. Why hasn't the insurance company paid to rebuild your building? And
but that damage has already occurred, has it not?
No, Your Honor, that damage is ongoing, and the longer that it takes for the Sarabians to be able to restore their fabrication facility and relocate back to their existing location, they don't have the ability to be able to manufacture in their current location. They're essentially a retail store now. So that tarnishment of their relationships cannot be remedied by money damages. So
let me ask a different question, if I may, and then I'll return the floor to Justice Blake. But after the original order that Judge Rufo entered, I assume that, I mean, that was a substantial, that was an amount substantially below the amount that you insisted was required at that time. Yet you made no attempt to go back to the judge and say, wait a minute, this is wholly inadequate. Why? I mean, the procedural posture of this request and this appeal suggests that anytime you go through discovery and discover the prospect of an additional claim, that you're able to go back and relitigate that and then come back to us for appellate review. It just strikes me as being an enormously inefficient use of judicial resources.
Respectfully, Your Honor, Judge Rufo, during the first injunctive hearing, asked American European to disclose those payments that it had authorized and did not dispute. Through artful omission and active concealment, they never disclosed that at the time that American European had authorized payment of the extra expense claim of $60,000, it had also authorized payment of the building loss claim at over more than $445,000.
But you went back. You can make the claim to Judge Canone that was fraud in the court. You could do. I mean, whatever you want to do. But the idea that is eligible for independent appellate review at that stage in an ongoing proceeding is, I have to say, a novel theory.
Respectfully, Your Honor, I don't think it's that novel. Actually, and when you a close reading of packaging industry suggests that review to this court is necessary to correct serious and possibly irreparable consequences. The fact that the insurance company for more than 5 years has actively thwarted the statutory scheme designed to protect the public interest and to ensure prompt payment of claims that are not disputed, and to avoid forcing the insured to pursue needless adversarial hoops and litigation to enforce their rights under the policy under this charade of policyholder fraud is the very reason why separate review is necessary before this court. And the fact that we have now waited this long and the American European had agreed to try and stay this appeal to discuss settlement and then never participated in that is yet another example of how they are willfully thwarting the statutory scheme and trying to leverage a settlement at a time when the insured is at its most financially harmed. And
I'm going to jump back in now, counsel.
Thank you.
Yeah, yes or no? Do you agree that we're reviewing for an abuse of discretion?
Yes, in part.
Okay. You talk about something that you've called a refined preliminary injunction standard, and I know that you have cited taxpayer groups sort of as acting on their own behalf under 93A. Do you have any cases involving private parties separate and apart from taxpayer groups that have sued on their own behalf under 93A in which this refined PI standard has been applied?
Unfortunately, no, and not for a lack of trying. I appreciate the question. I'm not familiar with a particular case where a private insured litigant stands in the shoes as a a private attorney general to enforce under Chapter 93A. However, my collective reading of the cases is that it's supported. Excuse me.
You spent a good amount of your brief talking about the insurer's admitted statutory violations, and you cite to record 232 to 237, and I didn't specifically see where there were admissions to statutory violations. So could you flush that out for me? If they're not there, where are they in the record?
The record numbers a tremendous number of pages, Justice Blake, and I'm happy to respond directly with those pagination references.
Well, you cite to 232 to 237, so those are 5 pages. If you could look at those, I don't see admissions there. I guess I'm trying to understand what you're asking us to view as admissions.
I'm going to pull that up right now while we're speaking. I would like to draw attention to what is effectively, I'm bringing that up now.
So these are the requests for admissions starting at page 232, I believe, is where you say these admissions to statutory violations have occurred.
Yes, 1 second, please. Oh, goodness, I opened the wrong one. I will return to that one momentarily, Justice Blake. With respect to the statutory violations, it is clear that the insurer had the obligation, both under the policy and under General Laws, Chapter 175, Section 99, 100, and 102, to pay or dispute within 30 days any claim that it received. It had boots on the ground for more than 2 years. It failed to undertake any opportunity to examine the insureds under oath, which it has the right to do under both the policy and the statutory scheme. They refused they refused the insured's invitation.
But
to
so are
submit-
those admissions, or are you asking us to draw inferences from those actions?
I guess the latter, Your Honor, respectfully. Those,
Right, they have not stated affirmatively, we admit to statutory violations.
They have stated affirmatively that they received the written demand for reference. They have stated affirmatively that the claims are covered under the policy. They have stated affirmatively that the claims, although covered, have not been paid.
And so from that, we infer a statutory violation.
Thank you, Your Honor. Yes, that's correct.
Okay.
That is a better characterization.
Your sister raises at page 12 of her brief on the question of this standard of a refined preliminary injunction that you did not raise that below and therefore it's waived. And I know that in your reply brief, I think it's at page 6 or so, you deny that, but where can I find information about you raising this standard below such that it doesn't constitute waiver?
Respectfully, the issue of the refined standard was discussed more generally. It's not actually quoted in the lower briefs, in the courts before the lower briefs. Okay. The revised standard was a reaction to the changed circumstances brought by the artful omission of the approved but an undisputed building loss payment. That was not discovered until afterwards. And respectfully, that brought about the changed circumstances warranting re-examination of the merits of the injunction before this court. And so I will also note, for Your Honor, that American European brought a motion to dismiss, which they lost on. They brought a motion to stay to refer the case to statutory reference after they refused the insured's invitation. That was all done after the policy's expiration of the 2-year limitations period. Judge Rufo,
I have another technical question, and I see that your time is getting short. So yes. At page 20 of your sister's brief, she says that you referenced 2 documents at 623 and 625 that were not before the trial judge or the motion judge below, and we shouldn't consider them. Do you agree that those were not before the motion judge?
I believe she's referring to the second insurer's response to the request for admissions.
Right.
Again, those were not submitted to the lower court because they were not received timely. However, this falls into the issue of was there, by their admissions, a stated case that this court may properly review on re-examination of the request for injunctive relief.
And with my chief's permission, I see that we're short on time. I have one additional question, Chief.
Yes.
Okay.
Thank you,
so,
Chief.
Counsel, if somewhat follows up on what Chief Justice Green asked you, which is if I take your argument to its natural conclusion, I would say that each time you discovered something, if we adopt your philosophy, each time we discover something, you can go back in and get an additional injunction. And so then what is the point of a trial if you can get all of this relief under the guise of a preliminary injunction?
Thank you, Your Honor. We're not trying to ask for relief that ultimately will bear out at trial. This is preliminary relief that is designed to save the business from its being shuttered after 52 years and to save the property from foreclosure. Preservation of that status quo is essential to both parties, to their claims going forward, and does not in any way impair the insurance company's ability to be able to argue its policyholder fraud or any defense that it may have with respect to waiver, which the insureds argue otherwise. All I'm suggesting is this preliminary relief is absolutely necessary to preserve any further loss of goodwill and to protect loss from foreclosure of the real property that was caused by the insurance company's failure to disclose to the court the first time around that it had approved for payment an undisputed building loss claim. It had paid all other claims.
Thank you. That answers my question. Thank you very much.
Thank you very much.
We'll hear from the insurer.
Good morning, Your Honors. May it please the court. From American European's perspective, this is an appeal that is about the abuse of discretion standard. The Justice Canone's ruling can only be overturned if she abused her discretion. And an abuse of discretion analysis consists of looking at whether the proper legal standard was applied and whether there was reasonable factual support in the record for whatever action was taken. And in this case, I think it's fairly clear that there was an appropriate legal standard applied. Justice Canone referenced in the brief docket entry, packaging industries, and the underlying legal conclusions, to the extent that you can infer that she rejected my brother's various arguments at hearing, were also not erroneous. It has been.
Well, let me interrupt you and ask you this. When the Sarabians discovered what they have called additional undisputed sums, would you agree that that's a change of circumstance?
No, Your Honor.
Why not? And do you have a case that says that?
Well, first of all, it wasn't a changed circumstance and it wasn't a discovery. The Sarabians were aware of it since January of 18, that American European was hoping to agree to some valuation based on Burke, and they were provided with that.
Wait a second, they knew about the 445 at the time of Judge Rufo's hearing or Judge Canone's hearing, or both?
Both. They were aware of the Burke estimate, and that American European knew, or that American European had offered to make an agreement with them for that amount before they even filed suit. That was the response to the email that Attorney Tomlinson has described as a demand for reference. They said, settle or we will go to reference, and American European said, this is what we're willing to do. And thereafter, suit was filed. So the idea that the Burke estimate was somehow hidden, or American Europeans' willingness to agree, and I won't say that an agreement was reached, because an agreement has to be mutual. And it's my understanding that the Sarabians actually refused to agree. And that's why the 30-day period wasn't triggered. There was no agreement. But the fact that there was willingness on American Europeans' part to agree based on the Burke estimate has never been hidden and has been known since 2018.
Well, the question is, it seems to me, different about the willingness to agree to a higher number than the existence and content of the Burke estimate itself. Was the content and existence of the Burke estimate known to the Sarabians at the time of the hearing before Judge Rufo?
My understanding is that it was, Your Honor, that the Burke estimate was provided to them in the context of negotiations between American European, their independent adjuster, Paul Battaglino, and at that time, the Sarabians, I believe, were assisted by their—
And you say that's your understanding. I mean, we unfortunately or fortunately are confined to the record. What do we have in the record to tell us one way or the other?
Well, it's
because to the extent that you are relying on their awareness of it at a prior time, we need to have a foundation in the record.
Well, Your Honor, it's a bit metaphysical, because to the extent that I became aware of their contention that the Burke estimate was new, the record was already closed. If they had made that representation earlier, we would have submitted the documents at that time.
Well, you can move to supplement the record if there were documents that demonstrate the existence, but the thing about our record is that it's anything but metaphysical. It is what it is. And so if it's not in the record, we can't rely on it. I'm sorry.
Counsel, was your client asked to participate in reference proceedings, and did they decline to do so?
Your Honor, I believe that actually in the record there is an email from the Sarabians, which says basically, we demand this claim be settled, or else we will demand this go to reference or preserve our rights under 93A. It was not a clear email. And it was after that email. You don't think that
tantamount to a denial or an invitation and denial? If we were to determine otherwise, that the insurance company denied or declined to go to reference, what are the consequences of that?
Well, the primary consequence is essentially what has been going on since 2018, which is that the only way to determine value would be through litigation. That's what happens when reference is waived. The idea that if there is no reference, then the insurance company is just stuck with whatever valuation the plaintiff points at is not the consequence of denying reference.
On the question of likelihood of success on the merits, my understanding is that your primary argument is that the Sarabians participated in some kind of a fraud. So is there something in addition to that argument on success of the merits, and I want to understand and ask you a few more questions about the fraud. So could you first answer, is the lion's share of your argument that the Sarabians committed fraud and that's why they're unlikely to succeed on the merits?
I wouldn't call it fraud. I would call it deliberate exaggeration of value and withholding of information, but that's the primary argument we advanced before the lower court.
And is that because of the mortgagee?
It's not solely because of the mortgagee, no.
Okay, so what else is there?
Well, in the course of litigation and after the complaint was filed, American European determined that representations made about interests in the property and the nature of the insured's interests were untrue. This included UCC financing statements representing that others had interest in inventory. And through the course of discovery, more and more admissions had come to light, including the Sarabians' answers to interrogatories, in which we requested the basis for their demand for $9,000 of cash. And they pointed out, well, we usually have cash around, which I would say is a deliberate exaggeration in value, which is sufficient to void a policy.
So can I take your characterization as a deliberate exaggeration as intentional as opposed to confusion or mistake?
Well, I think that the case that most explores that is the Gachigian pair of cases back from the 30s. If an insurer and an insured aren't free to dicker about value and say, this is what I think it's worth, offering the highest value and hope that maybe something free will be reached. I believe that the standard is willfully exaggerate. I believe that's what's in Gachigian, and I think that's what occurred here.
I don't know if it's the Zoom disconnect, but I'm having trouble understanding what case you're citing.
Oh, sorry, Gachigian. It's a difficult one. It's cited in my each of my cases below, and it starts with GECHIJ, I think IAN.
Yeah, I don't see that in your appellee brief, but I'll look for it in your brief below.
It's 298 Mass 487.
Thank you, Chief.
It's in the table of authorities in the brief.
Thank you. If it was simply confusion over who the mortgagee was, and I understand that's not what you're arguing, I'm just hypothetically, they got wrong who the mortgagee was. Would that constitute deliberate exaggeration?
I don't think so, to be honest. I think that it's probably difficult for a lot of people to say exactly who holds their mortgage at a given time, and the best you can ask for is the information that American European, in fact, did ask for, which is show us that the mortgage is discharged, give us a statement, and that's precisely what we cited below that the Sarabians refused to do.
Can you address your brother's argument that money damages on these facts is insufficient?
Yes. Essentially, it's a bit difficult to say that money damages are insufficient when what you're looking for are money damages. But the few cases that have held that you can demand payment by way of preliminary injunction in order to forestall some later harm to a business have actually dealt with very narrow circumstances that don't fit the case here. In the Boston Athletic Association, payment of funds was permitted because it was from a specific limited fund that was designated for a certain use. In the cases addressing that loss of a business is a potential harm that cannot be redressed through damages, they often deal with not necessarily a payment required to forestall that harm, but that the entire business model will be destroyed by a proposed action such as the smoking ban with a bar, something like that. In this case, the Sarabians are business owners. They stand to lose the loss of a business and the profits from it. This is not similar to the end of all possible business in a category. It's a harm that can be calculated and redressed at the end of the case.
If I could just, and maybe I'm going a little further back than we've progressed, but in the initial hearing before Judge Rufo, there was never in my reading of the transcript a determination of any of the necessary elements of a preliminary injunction, such as irreparable harm. It appears as though he simply brokered a settlement in order to get some money to flow. There was no findings, and any attempt to bootstrap any irreparable harm, I think, is inappropriate, and I didn't see any further argument before Judge Cannone that even addressed the irreparable harm. So isn't that alone is sufficient to say she didn't abuse her discretion, as there was no showing of irreparable harm? I mean, I don't mean to be as basic as I can, but why can't we just say that?
Well, I think you phrased it much better than I did or could have. That we can't bootstrap onto the absence of findings from Judge Rufo in the prior hearing, however the result was reached.
And there was no argument, I believe, at Judge Cannone's hearing regarding the irreparable harm being the violation of any statutory schemes.
I believe you're correct, although I did not review that transcript since the weekend, but I believe that you are correct there. But I think that essentially gets to the essence of the argument here, which is Justice Cannone acted properly. There was no abuse of discretion here. She applied the proper standard for preliminary injunction. She clearly, if you read the hearing transcript, considered arguments from both parties, and there was adequate evidence in the record to suggest the findings that are plain that she did make, that there was no irreparable harm and there was no demonstrated likelihood of success on the merits. I don't think that there's anything that I can say to improve on that.
Well, then, unless there are further questions from the panel, and seeing none, I will treat this case as submitted, and the argument is concluded. That will conclude our session today, and I want to thank our session clerk for doing a terrific job of keeping us on track despite the occasional technical difficulty. Thank you.